So let me show you how the judge already determined that I'm factually innocent of all the crimes I'm accused of. You can go to Pacer to verify this, but I'm going to walk you through the trial process, the documents involved, so you can go on Pacer and verify it. So it's case 10 cr-00326 DSD-FLN. December 10th, document 1, indictment. March 3rd, 2011, document 53, second indictment. April 25th, 2011.
Trial brief here, number 64. I'm going to reference that a lot. They kind of lay out their case in chief. They say that I fabricated a bunch of evidence to create plausible deniability and that I'm a mastermind in a massive fraud scheme that involves real estate in Minneapolis-St. Paul area. And I created a fictitious letter from the police chief, which during trial they realized was genuine. So then to keep it out of trial, because I told you how they rig trials is they prevent you from presenting your evidence. They keep things out of trial, which they did in this case. That's why more than 2/3 of my restitution didn't come from the trial verdict. It came from the sentencing hearing. In this trial brief, they lay out all these specific documents that they say that I made up and I'm lying, this and that.
Trial brief. This is the government's case in chief. This is where they argue that I fabricated a bunch of evidence to create plausible deniability, including fake letters and emails, and I was the fraud mastermind, right? They refer to this document, number 64. They reference evidence or their case in chief in their sentencing document, number 98, which we'll get to later.
Then there's, of course, a sealed document that goes with that. Then we've got the second superseding indictment down here, another one, right? Another sealed document.
But then on May 2nd, document number 66 is the third indictment. So indictment number 1, December, indictment number 2, March, and then now in May, indictment number 3. Before trial, they were trying to get me to tell on other people and help them. I refused to cooperate. After they indicted me, they were still trying. I refused, so they indicted me, a more severe indictment and so on and so forth. That's what they do.
Then we've got order denying motion for continuance of trial. So we've got this indictment on the 2nd, and we're going to trial.
May 16th through June 2nd, that's trial. The trial transcripts, if not all of them, most of them are on Pacer.
So we made a motion for suspension of trial. Go down here, document 91. We've got the jury verdict. Of course, that went against me. We go down here to my motion, 92 docs 92 and 93. That's where I asked for a new trial. My attorney says that the evidence was insufficient. The judge denies that, says the evidence was sufficient based on the jury verdict.
Now, on June 16th, after I lost the trial, and I've talked about, even with the indictment process, the elimination of no bills the prosecutor allowed into the prosecution room. I've talked about how they rigged the entire process at the trial, how they suppress your evidence. After trial, in docs 92 and 93 on Pacer, in this case, 10 CR 00326. This is in the District of Minnesota. Docs 92-93, we made a motion for judgment of acquittal based on insufficient evidence. Now, what's important, in Doc 94, it was the denied. The judge denied that motion, and he said that there was enough evidence to convict me in the light most favorable to the government. Now that's important because that's how that document had to be analyzed in that situation. So order denied. Then we go to the government sentencing. That's doc number 98. They filed this on September 15th, 2011.
And then we get down here to document 98 filed on September 15th, 2011, right? So we've got the jury verdict on July 2nd, 2011. And then we've got the sentencing, the position of sentencing, 9/15/2011. That's doc 98. This is where the government now opens the door. Normally a judge can't, open the verdict back up and say, well, you know what, I actually saw it different than the jury. I don't see where the defendant committed a crime. The judge can't normally do that. But I'll tell you that the government opened the door for that with this right here, because in this position on sentencing, which I'll show you.
And that was about a month and a half before my sentencing hearing on October 31st, 2011. In this sentencing position, doc 98, the government argues that I perjured myself again and again, contradicted all the witnesses, I should be enhanced for obstruction of justice, that I should face a sentence of 27 to 33 years, and they reference evidence that they say I fabricated and falsified, to create exculpatory and plausible deniability. They again reiterate that I'm this fraud mastermind and that I got on the stand and lied about everything. So that's okay. So here's the other document. Now remember, my sentencing was October 31st, 2011. This is from September 15th, 2011. So I don't know, about a month and a half before. This is the government sentencing position. So when I went to make my allocation speech, this had already been presented to me in the court. And so they're going to the court and they're saying that, I perjured myself at trial. And I did it repeatedly, egregiously. And let's see what else. They said that I testified, for example, that my role with Minnesota One was that of a mere salesman. I knew very little about mortgage brokering itself. And they said that my testimony was contradicted by substantially every piece of evidence. They say these loan applications bore my name. And, what else did it say? 2 resumes. So give you a little background. I denied that the resumes were mine. I didn't have a computer at this office. Specifically said that's a fake resume, and that's a lie. I didn't make that. And then virtually on every loan application, my name was forged. That came out at trial. But here they are in sentencing, still saying that I lied about all this stuff. Going down here, and down here they said that under USSG subsection 3C11 that because of my repeated non-subtle perjury at trial, that my offense level should be a 41 and I should be in prison for 324 to 405, right? So that's 27 to 33 years. And the government says, respectfully recommends a guideline sentence, and they recognize that the guidelines range in this case is high and does not make this recommendation lightly or without reflection on the nature and circumstances of Mr. Spncer's offense conduct, right? We'll go all the way to the bottom.
Now, the reason I draw your attention to this is because in this sentencing memorandum, where they're asking the court, specifically under USSG 3C1.1, they're asking the court to make a required independent factual finding, and not just to intent, but in some instances to the occurrence of conduct itself, right? Because if we have emails and letters that you say I fabricated, either I fabricated them or I didn't, right? If I made fake documents, I know them to be fake. So if they're fake at all, then clearly I know they're fake because you're saying, government, that I made them. So you're asking the court, you're opening up the door now. You've basically put your entire case in chief back up for litigation for an independent factual finding that you asked for. And you listed everything essentially, and even referenced docs from your trial brief in your case in chief. You're asking the judge now to put my defense to the test, just so we're clear on what's going to happen now. It clearly argues virtually everything that they argued in this document 64 back here. And they re-argue that I lied on everything and that I should get enhanced now for perjury, right? Back to Doc 98.
And you could read this again. It's Doc 98, filed on September 15, 2011, right? In this case, 10 cr-00326 DSD FLN, right? But the persistent and thoroughgoing dishonesty, which pervades everything Mr. Spncer did in connection with the offense. I had to read that. It sounds stupid, right? And then in avoiding responsibility for it in the repeated, fundamental, and obvious perjury committed by Mr. Spncer during his ill-advised trial testimony. You get where we're going here, right? The government is saying that I'm a liar. They're accusing me of all these lies and everything. Now, I went to trial, testified for myself, said that, first of all, the government is lying. These documents are real. And there was no crime. There was no conspiracy. You made them up. I'm saying all of those things.
And I just want to make sure that the point I'm making is clear here, so I'm going to say this one more time right now. In this sentencing memorandum, where they're asking the court specifically under USSG 3C1.1.
So that's very important because they're specifically asking the judge now to make an independent factual finding on everything they just said. So we're here where the judge maybe couldn't overturn the jury verdict because of just the way and the procedure, the way it was presented. It comes kind of into question of whether or not he can do it now.
They're asking the court to make a required independent factual finding
based on the fact that I denied everything, and if my testimony is true, I have to be acquitted. And the government's asking the court to rule on essentially just that.
They're asking the court to make a required independent factual finding.
And they're very specific in doc number 98, filed on September 15th, 2011. I encourage you to read it. Back and forth here, them accusing me and me accusing them. So that's what's going on. That's what's headlining.
They're asking the court to make a required independent factual finding.
The sentencing. And then we have the sentencing hearing and allocution. In the allocution statement after the determination about loss, but before the judge ruled on perjury,
to make a required independent factual finding.
Document 155, it's that document on the bottom. And this right here is the evidence hearing to determine loss, right? So that's where we're at after these dates. We're on October 31st, and I'm coming out of the county jail. I'm brought to court for my sentencing, and they don't want to give me my tie. It's a fiasco. Finally, I'm out there for the sentencing, and I'm listening to the evidentiary hearing.
They're asking the court to make a required independent factual finding.
I have not yet responded to the allegations in doc number 98, the government's positioning on sentencing, where they say I lie, right? And they bring back their case in chief, say I lied about everything.
They're asking the court to make a required independent factual finding.
I haven't had a chance to defend myself against that yet. The sentencing hearing document, I'm going to get into this. I'm not going to read the whole thing, but I'm going to go through the bullet points about what I said in my allocation speech. So let's go through and let me show you what I said about all these lowlifes, including the prosecutor McLaughlin, lowlife liar. Steve Kuntzman, special agent FBI. You're a lowlife. You're a liar. Okay, so from Doc 155, right? This is my allocation speech, and it was pretty extensive. It went from page 93 all the way to page 111. And I'm just going to give you the bullet points now from this document, just so you know, right before I was sentenced, right after the government had filed its sentencing memorandum, and then we had the loss determination hearing, and then they were arguing that I should, have this perjury, right? But before they made their final argument for the perjury, they're asking the court to make a required independent factual finding. And then right before the judge ruled on my sentence and whether in fact I did perjure myself at all, they're asking the court to make a required independent factual finding. And I'm going to put this up on another board, so we're going to transfer to that. But that's where we're at now. We're in the sentencing hearing. Okay, so just stay with me. Factual innocence. I'm going to make that clear in this trial. So these are just the bullet points. Okay, so just so we're clear, trial, post-trial, government sentencing. We're at the hearing, and they've already, tried to dump this big loss amount on me, went through their case again, everything they say that I did. They're claiming that I perjured myself, and now it's time for me to give my allocation speech in document 155, starting on page 92. That's where we're at right now.
These are just the bullet points.
4 times I asserted my innocence, basically denied everything that the government said. I reiterated and affirmed the truthfulness of my trial testimony. I accused the government of creating fictions, using grandiloquence, suppressing exculpatory evidence. I talked about how they use outright lying and cheating. I accused the government of willfully presenting fabricated documents, ignoring contradictory testimony, smoke and mirror tactics, half-truth, rehearsed testimony, weak evidence, alleging the government used distraction techniques during witness cross-examination, which they did.
They're asking the court to make a required independent factual finding.
I accused the government of falsifying evidence, lying on me, building a false case. I reiterated the truthfulness of my trial testimony and again said that I was innocent, had nothing to do with any crime or any fraud. That was on October 31st.
So in my allocution speech in front of the same judge that was at the trial and would have seen this, so it either happened or didn't happen, I bring up the fact that the government constantly distracted the jury when my defense team was putting on its defense right at key moments of climactic points of emphasis. I said that. So when we look at the judge's ruling, right, he was there, he saw that. And the prosecutor's going to get up after I'm done with this allocution speech and he's going to complain about it, right? So they're asking the court to make a required independent factual finding. The judge was there at trial. He knows whether or not this prosecutor was doing stuff and whether or not these things that I'm saying happened. And keep in mind, the government is the one that moved the court to make this independent factual determination.
That was on October 31st. Okay, so we're in document 155, and I'm just going to go through some bullet points with you because we went, if you remember, we went from over here and we had the trial, the pretrial document number 64, where they kind of say, oh, this is what we're going to prove at trial. We had the trial. Post-trial, motions for acquittal, denials, docs 92, 93, 94. This is in case 10-3261 DSD FLN. Now we have the government sentencing position where they make all of those claims.
They're asking the court to make a required independent factual finding.
Now we're on October 31st, 2011, and the government is now going to make their case against me for additional loss amount. When we came out of trial, they had less than a $3 million judgment with the jury, but now they want to boost that to almost $8 million, and so they're looking for another $5 million in related conduct that they're going to present evidence on and talk about here. I'm going to go through some bullet points of what they said, just so you get the gist of it. That they interviewed Steve Kutzman. He was the case manager. They talked to Brian Lenton, co-defendant. He testified. He was a co-defendant who testified, and he was an appraiser. The alleged testimony was that I told the appraiser to inflate the values of the appraisal. And then they talk about Alex was a witness. They say he bought some more properties. Remember, they're trying to take that $3 million and turn it into $8 million. That's what they're doing. Now, they say, and this is on page 12 of 128, document 155, was one of the witnesses for Mr. Spncer at trial, as I recall. Does that square with your recollection? Yes, he testified for the defense. Prior to them intruding into my attorney-client privilege with William Hogle, he was going to actually testify for the prosecution, but that's one thing they changed when they intruded and got that unlawful preview of my defense. Mossman and we both said on the stand that the government was trying to put words in their mouth and get them to lie. So I think that's important because they bring that up. There was testimony here about checks that went back to me from Adam Christensen, Rat of the Month. They talk about silent second mortgages. They say that I made that. I perpetuated the fraud with silent second mortgages. They talk about I lied on the 1003. They essentially, to put all this other stuff on me here.
They're asking the court to make a required independent factual finding.
To get this extra $5 million or almost $5 million, to add it on to get this $7.8 million that they want. After that, I make my allocation speech. All this stuff, just so we're clear, I said in open court after all that was said about me and right before the judge
To make independent factual finding.
is going to either sentence me to 27 to 33, 34 years or not.
Just the bullet points.
4 times I asserted my innocence, basically denied everything that the government said. I reiterated and affirmed the truthfulness of my trial testimony. I accused the government of creating fictions, using grandiloquence, suppressing exculpatory evidence. I talked about how they use outright lying and cheating. I accused the government of willfully presenting fabricated documents, ignoring contradictory testimony, smoke and mirror tactics, half-truth, rehearsed testimony, weak evidence, alleging the government used distraction techniques during witness cross-examination, which they did. And then after that, the prosecutor, he argues again that I lied at trial and just now on allocation, right? So, okay, so let me read to you what the prosecutor, Mr. David McLaughlin, says after that, right? Oh, he's not happy. I think there's one guidelines question still open, and that is whether or not this defendant perjured himself when he took the stand at trial. It was the worst testimony I've seen in my career. It was clearly false in its detail and its major thrust. I think the jury convicted Mr. Spncer so fast in part because he took the stand and lied about everything. I guess, Your Honor, I don't have a whole lot to add to the papers we filed. He's talking about like the sentencing opinion memorandum, that goofy document we talked about I just showed you, that goofy ass document. Okay. I don't know if it's grandiosity or arrogance, and I don't want to be heard as condemnatory. In using those words, I'm just trying to describe what we saw on the stand and arguably just now. So he's talking about my allocation, right? This is a man who really thinks he can lie his way out of everything. I was going to show the court. I activated the document cams. An example. There are many made up documents in this case, right? So he's putting a document up, right? One of the documents, remember, from the exculpatory documents. So we're about to get to where the rubber meets the road here with this stupid contention by the government. Anyway, Mr. Spncer really thinks he can lie his way out of everything. And to me, this is a section 3553A factor that most predominantly jumps off the page. I don't see that conduct as consistent with law-abiding lifestyle. I think that recidivism, given the kind of arrogance and grandiosity and proclivity towards lying that we see here, it's a high likelihood. So for the reasons stated in our papers and the reasons just stated, we advocate for a guideline sentence. Okay, so here's the prosecutor, David, calling me a liar again. It's the worst testimony he's ever seen. I've lied about everything. He's brought back, because this is important now, David, you brought back the documents that you said that I fabricated.
They're asking the court to make a required independent factual finding.
Just so we're setting the stage now. David's complaining. He's asking, Mr. McLaughlin is asking Judge Doty to award him a guideline sentence of 27 to 30, almost 34 years, and, make this factual finding that I committed perjury, because that's what we're talking about here. A mandatory factual finding.
And so David's going to get what he's asking for here. He's asked the court to make an independent factual determination, to look at the evidence and decide if everything I said is a lie like he contends it is, right? He brought it all back in and he's asking for this factual determination. He's about to get one, right? And he needs to prove that I'm lying now. The burn's on him by a preponderance, just 51-49. He has to prove that it's more likely than not that I'm lying when I've denied guilt completely.
So they put the jury's verdict at risk because they're saying all of this stuff again, and then I say what I say in my allocution. I deny all of this. I reiterate my trial testimony. I reiterate my innocence, and not only that, I again accuse the government of making false accusations, right? So I do all of that in my allocation, right? And that starts on page 92, right? Doc 155 to page 111, and then you can read what the prosecutor says. I'm going to show you, and then let's look at what the judge ruled on this, which was essentially a bench trial of the entire case.
So as I read this to you, let me just be clear. This isn't an act of mercy. This is a mandatory factual finding. This is not permissive. He doesn't get to choose to be merciful. He has to find these facts.
All right, so I'm going to go over here. This is Judge ruling. Now this is document 155, page 116.
And so the judge says, a matter of guidelines application has also arisen with respect to the defendant's testimony during trial. The government objects to paragraph 52 of the PSR, which does not apply a 2-level enhancement for obstruction of justice. The government argues that the defendant committed perjury by denying his guilt while under oath. An obstruction of justice enhancement for perjury is warranted when the court finds by a preponderance of the evidence that the defendant willfully made false statements under oath about a material matter. And the court went on to say, at trial, defendant repeatedly testified that he had nothing to do with the fraudulent activity and that he was a telemarketer who knew very little about mortgage brokering. And although the government presented overwhelming evidence of defendant's guilt, the court does not find the obstruction of justice enhancement warranted, and therefore the court will overrule the government's motion. So the government lost. That ruling says it's more likely than not that I'm telling the truth. Keep in mind, 5 minutes before that, I had made and reiterated all those accusations against the government, calling them liars, fabricating evidence and testimony. Just 5 minutes before that. And that's the ruling. A minute after, the prosecution again argues that I should get hit with perjury and that I lied about everything. The government couldn't meet its burden by a preponderance of the evidence that I was lying, as they claimed, when I asserted my innocence. So we can look at it like this. The judge is saying that, there was enough evidence, at least based on what the jury knew. But of course, the court has seen all the evidence, even the suppressed evidence, the evidence that the jury hasn't seen. The court is aware of that. The court has total information. And when they denied my motions for acquittal, the court had to say, listen, in the light most favorable to the government, sure. But here now you've asked me to make an independent factual finding. And when I make an independent factual finding, then the case isn't in your favor. And it's not so clear. And in fact, you can't really prove your case even by a preponderance of the evidence.
At trial, defendant repeatedly testified that he had nothing to do with the fraudulent activity and that he was a telemarketer who knew very little about mortgage brokering. What was the controversy? The controversy was about whether or not I was telling the truth. And what was it that I was supposedly lying about? Let's see. Fabricated documents specifically mentioned in document 98 and specifically argued earlier in the day in the sentencing hearing, right? So this $5 million, supposedly they proved by a preponderance that it was part of related conduct. However, I then gave my allocution where I reiterated my trial testimony and my accusations against the government, and I won.
So the government lost. That ruling says it's more likely than not that I'm telling the truth. And that's the ruling. The government couldn't meet its burden by a preponderance of the evidence that I was lying, as they claimed, when I asserted my innocence.
It was proven more likely than not that I was telling the truth. Said another way, it was more likely than not that the government did fabricate evidence against me. That's what I said. That's what took up all those pages on document 155. You can read what I said. You can read what they argued in document 98. You can read what they argued in their trial brief in Doc 64, and you can see that they brought their entire case in chief into question when they asked the judge to make an independent factual determination on the evidence. Did Mr. Spncer lie when he took the stand and denied everything? And the answer to that was more likely than not, no. No, he did not lie.
Contrary to the government's repeated claims that my testimony and documents were fabricated or false, the court did not find any such statements or materials to be false at all, let alone willfully false.
The government could not prove by a mere preponderance that my defense was a lie, which negates their entire case.
Facts. Under USSG subsection 3C1.1, the court was required to make an independent factual finding, and the refusal to apply the enhancement constitutes a legal and factual rejection of the government's position, not just to its intent, but in some instances as to the occurrence of the conduct itself.
Yet somehow, they got a jury verdict over here that supposedly had evidence beyond a reasonable doubt. You might say it's because the jury can choose who to believe. And if the judge can choose to believe me in that situation, he's seen all the evidence, even evidence the jury didn't see, right? He knows the whole story. And he just listened to me for 25 minutes berate the government about their lying, their false testimony, fabricated evidence, and then ruled in my favor on a credibility determination while talking about their evidence. He basically said, yeah, the jury believed your evidence, but I did not. That's what he said. And by a preponderance of the evidence, I am factually innocent, because if what I said is true, and the ruling is more likely than not it is, then that negates everything.
And that is because many of the government's claims hinged on binary factual propositions, i.e. either I authored the exculpatory emails or I did not. The court's finding that the enhancement was unwarranted necessarily implies that the evidence was insufficient to prove either falsity or authorship, even by a preponderance.
It definitely negates this $5 million. It negates anything. It definitely calls into question, why was I put in prison for 10 years? Even if you don't upset the jury verdict, unless it's a predetermination to send me to prison, didn't have to.
Because of the government's claims, this was a bench trial into my guilt, which the government lost even when their burden was the lowest. In a bench trial to get conviction, they would have had to prove what they could not prove here in sentencing.
I'm factually innocent.
To recap, the court did not find that my statements were false at all, nor that I fabricated evidence. Rather, it found
that it's more likely than not, in your own words, that despite what the government said, that when I said I didn't do it, and then what you just heard 5 minutes before you made this ruling, me accusing the government of lying and fabricating a case against me, you rule in my favor and say that I wasn't lying.
That the government could not meet its burden even by the preponderance to prove that such conduct occurred.
That's factual innocence. Okay, so I just want to make sure that I sum up and that I'm clear. The government took me to trial. At trial, I denied everything. And then I filed for a motion of acquittal where the judge said, listen, I got to look at this in the light most favorable to the government. I have to deny your motion. We went to sentencing. Before sentencing, in document 98, they reiterated all their allegations, said that my defense for everything was a lie. It was all based on my testimony and fabricated document. We go to sentencing and you have the sentencing hearing. And I don't get to say anything. They say all this stuff about where the loss comes from and they calculate up the loss relative related conduct. But then I do get to now make my defense in my allocation speech, or is it that doesn't matter? My allocation speech doesn't matter. So the only thing that I'm just at risk for perjury, but I have nothing to gain if I win because like I won this. And my defense was a defense to all this stuff, even the stuff that preceded in the sentencing hearing, right? It negates all that. So you got to take all that off me, right? You can't just say, oh yeah, more likely than not, you're telling the truth. And then like just proceed like that doesn't change everything. That's factual innocence. That definitely changed everything. That's factual innocence. And sending me to prison, punishing me at all was completely unlawful because there's no factual basis for the punishment. That's factual innocence. Zero. That's factual innocence.